The owner of a business or a lessor of a business has an obligation to its invitees. That means the general public. So the owner of the business premises has to make certain that there are no hazards that any of their invitees or their guests are going to encounter, or at least make certain that they adequately warn them of anything that they may come across that could potentially harm them. And if they fail to do so, and that person's injured as a result, then they're liable to them for their damages. In your slip and fall cases, you see a lot of fractured wrists, a lot of fractured knees, a lot of ACL injuries, a lot of fractured patellas. Again, the injuries can also include back injuries and neck injuries as well. But more often than not, it's somebody who unexpectedly is hitting a concrete surface, is not prepared for the fall, and the impact can be tremendous. When it comes to slip and fall cases, there's a certain stigma that attaches to them that had this guest, if you will, been paying attention, they wouldn't have fallen. But while that is a bona fide defense in some cases, there are a lot of cases in which you're unable to perceive the hazard that you're about to encounter. If it's a clear liquid on a floor, you're not going to see it. If you're walking with a public shopping cart in front of you that's full of all those groceries that store wants you to buy, and you can't see what's on the floor ahead of you and you trip over it or you step on it, then they're liable for that. So there is a certain stigma that the property owners believe that they get to take advantage of, but more often than not, when you take the time to explain the circumstances to a reasonable jury, they understand what's happening. It is critical that a person who suffers a slip and fall act quickly, because the substance that's on the floor is going to be removed or cleaned up. The materials that might be on the ground are going to be cleaned up or removed. The object that might have fallen on the person is going to be removed. So it's absolutely critical that the person notified store management, that they ask for photographs of the scene, that they ask for witness statements. Now, one thing that helps plaintiffs in slip and fall cases more these days is because relatively recently the law regarding spoliation of evidence has undergone some redevelopment, if you will. The device that causes the injury is now becoming more and more important, and the property owner actually has an obligation to preserve these things, and if they don't, then they could be liable for the same or similar damages, although just under a different legal theory. The goal of the property owner and its insurance company is to settle these claims as quickly and as expeditiously as they can. They don't care about the actual value of the claim, and so they will typically try to offer slip and fall victims pennies on the dollar as far as the value of their claims are concerned. And what we routinely tell all our clients is do not be talking to any insurance companies at all. They're only there to get whatever information they can to use against you later. And even though they may promise you the world as far as sharing the information and wanting to pay your medical bills, those things don't happen. In your typical premises liability case, whoever controls and possesses the property is the person primarily responsible. So this could be a non-owner and it could be a non-lessor. You might have a general contractor in there who's actually got control of, let's say, a whole floor that he's in the process of remodeling. And if somebody's injured in a slip and fall, then you could have the general contractor liable. What makes our firm different from other firms is that we are local. We've specialized in this area. Our firm has been handling slip and fall cases since 1979. We've also practiced throughout the country in both state and federal courts. We are passionate about representing our clients. We take an interest in them. Many of our former clients are friends to whom we communicate with to this day. Client communication is critical. We return telephone calls and emails promptly, because a client should never go long at all waiting to hear what their attorney is doing. We are a small firm, and the advantage of having a small firm is I personally work on your case. Mr. DePaula personally works on your case. Your case and the preparation of that case, the appearance at court, trials, writing of appellate briefs, those are handled by the two of us, not someone else, not a paralegal, not a secretary. During the initial consultation with someone who suffered injuries in a slip and fall, we gather as much information as we can regarding the fall. We try to marshal or gather as much of the physical evidence, or at least try to locate where it is, because that's often critical and can disappear quickly. And we also notify the property owner immediately that if they're in possession of any of the evidence, they need to keep it and not dispose of it, or else they could be facing certain sanctions. We look into their injuries, we try to gather their medicals, we give them an idea as to what they can expect as far as the treatment that we've seen in the past. We explain to them what the nature of or the panoply of damages that are available to them. We explain the process to them, and we assure them that we'll be with them every step of the way, and we also assure them that we work for them. What they say goes, and they control every step of the process.